Hello and welcome, dear students. Today we are going to discuss an important topic on salient features of the Special Marriage Act 1954. Introduction. Marriage is regarded as an essential and integral part of the society. It is an institution of peace and satisfaction. It is the very substratum of a chaste, civilized, dignified, disciplined and well-ordered society. In India, different laws, generally known as personal laws, apply to different communities in the matters of marriage, divorce, maintenance, etc. All these laws derive their authority and authenticity mainly from their respective religions. Besides these religious-based personal laws, there is one more law, viz. The Special Marriage Act 1954, which is a secular law which applies to the parties irrespective of their religion. This law governs certain special matrimonial matters under certain situations covered by the Act. The object of the Act is to provide a form of marriage which is secular in character. Salient features. First, religion. One of the outstanding features of this Act is that religion is not an impediment to the marriage. Under all personal laws, interreligious marriages in general are not allowed. This law applies to all and allows marriage of any two persons irrespective of caste, creed or religion. Thus, interreligious or intercommunal or international marriages are possible in India only under this Act. The essential part is that a marriage under this Act must be in a civil marriage form, though parties are free to perform any other additional ceremonies they choose to perform. Two persons belonging to same or different religion can marry under this Act, and even atheists can also take advantage of this Act. Section 12, Clause 2 reads as, "The marriage may be solemnized in any form which the parties may choose to adopt, provided that it shall not be complete and binding on the parties unless each party says to the other in the presence of the marriage officer and the three witnesses and in any language understood by the parties." Number 2, monogamy. No person whose marriage is solemnized under this Act can marry again during the continuance of his or her marriage. If a person contracts any other marriage, he or she shall be deemed to have committed an offence of bigamy. Bigamous marriages are void. Section 44 of the Act says, "Every person whose marriage is solemnized under this Act and who during the lifetime of his or her wife or husband contracts any other marriage shall be subject to the penalties provided in Section 494 and Section 495 of the Indian Penal Code 1860, 45 of 1860, for the offence of marrying again during the lifetime of a husband or wife, and the marriage so contracted shall be void. At the time of marriage also, neither party to marriage must have his or her spouse living. Section 4, Clause A. Consent. A person must be of a sound mind at the time of marriage. The contracting parties at the time of marriage contract must be capable of understanding it and forming a rational judgment. Section 4, Clause B. Section 4 of the Special Marriage Act 1954 lays down the important conditions relating to solemnization of special marriages. Notwithstanding anything contained in any other law for the time being in force relating to the solemnization of marriage, a marriage between any two persons may be solemnized under this act, if at the time of the marriage these conditions are fulfilled, namely, neither party has a spouse living, is incapable of giving a valid consent to it in the consequence of unsoundness of mind, or though capable of giving a valid consent has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children, or has been subject to recurrent attacks of insanity. The male has completed the age of 21 years and the female the age of 18 years. The parties are not within the degrees of prohibited relationship. However, the custom has been given significance. Proviso to section 4D says, provided that where a custom governing at least one of the parties permits of a marriage between them, such marriage may be solemnized, notwithstanding that they are within the degrees of prohibited relationship. It is significant to mention here that only those customs which have been accepted by the state will be applicable. The explanation makes it clear. Explanation: in this section, custom in relation to a person belonging to any tribe, community, group or family means any rule which the state government may, by notification in the official gazette, specify in this behalf as applicable to the members of that tribe, community, group or family, provided that no such notification shall be issued in relation to the members of any tribe, community, group or family, unless the state government is satisfied, 1. that such rule has been continuously and uniformly observed for a long time among those members. Number 2, that such rule is certain and not unreasonable or opposed to public policy, and that such rule, if applicable only to a family, has not been discontinued by the family. Void and voidable marriage. A marriage which is not valid may be either void or voidable. Void marriage has no legal effects and it is void ab initio, that is, right from its inception, and a voidable marriage is valid till it is annulled. Thus, as long as decree of nullity is not obtained, the parties are entitled to all rights and bound to fulfill all obligations of marriage. Any marriage solemnized under this act shall be declared null and void if any of the party was having a spouse living at the time of marriage. Consent was taken from the party who was of unsound mind. Consent was taken from the party who has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children. The male has not completed the age of 21 and the female the age of 18 years. The parties are within the degrees of prohibited relationship. The respondent was impotent at the time of the marriage and at the time of the institution of the suit. Section 24B. Voidable marriages. Any marriage solemnized under this act shall be voidable and may be annulled by a decree of nullity if the marriage has not been consummated owing to the willful refusal of the respondent. The respondent at the time of the marriage was pregnant. However, if the respondent was pregnant by the petitioner, marriage is valid. The consent of either party to the marriage was obtained by coercion or fraud. Section 25. it becomes clear that consent has not been given too much of significance by the Act. It is only when it is given by a lunatic the marriage will be void, otherwise it is simply voidable. In Asha Qureshi versus Afaq Qureshi, AIR 2002, the wife did not disclose the fact that she was married and was a widow at the time of marriage. The non-disclosure was held by the court material misrepresentation, and it was laid down that it constituted a fraud under the Contract Act 1872. Accordingly, the marriage was annulled by the decree of nullity. Prohibitions. Parties to the marriage should not be within prohibited degrees of relation. The degrees of prohibited relationship of the persons are mentioned in Part 1 and Part 2 of the first schedule. However, if the custom allows such a marriage between the parties, such marriage may be solemnized, notwithstanding that they are within the degrees of prohibited relationship. Section 4D. Marriage formalities. Notice of intended marriage. As Section 5 reveals, for marriage, the parties concerned have to give notice of 30 days to the registrar of marriage of their intention to get married under this Act. The notice is to be given to the district registrar wherein the party is residing. The registrar shall keep the notice on record and keep the true copy of the notice in the marriage notice book. A copy of the notice will be displayed by the registrar on the front portion of his office. The marriage notice book would be allowed to be inspected without any charge. If either parties to the intended marriage do not permanently reside in the local limits of the district in which notice has been given, it is necessary to send a copy of the notice to the registrar of the place where that party permanently resides. It is only after the publication of notice under Section 6, subsection 2 that objection under Section 7 can be taken. Publication and objection, if any, after the notice of marriage is published, objection, if any, against the same is to be taken before the registrar within 30 days of the publication of the notice under Section 7. If no objection is raised, then marriage can be performed after completion of 30 days. But if some objection is taken, it would be noted. Proceedings regarding objection would be done as per Section 8. After enquiry of the objection, if the registrar thinks that it is not necessary to stop the marriage ceremony, he will allow the marriage ceremony to proceed. For enquiry into the objections, the registrar shall not take more than 30 days. However, if after enquiry objection is sustained, the marriage would not be allowed to be performed. Against this refusal, an appeal lies to the district court, whose decision would be final. Registrar's investigating powers. Section 9 vests the investing registrar with powers similar to a civil court, that is, first, to examine witnesses and summoning them. Second, to compel them to produce document. Third, for search and inspection. Fourth, to take evidence on oath or affidavit. And 5, to issue commissions for taking evidence. All such proceedings are deemed to be a judicial proceeding within the meaning of Section 193 IPC. Subsection 2 of Section 9 provides that one who takes a false objection would be liable to pay costs in the form of compensation up to Rs 1000. Registrar can order to give certain amount to parties to a marriage from this sum, that is 1000 rupees. His order is deemed to be a decree of a court. Declaration of parties. Section 11 provides that in the presence of registrar of marriages and 3 witnesses, the parties to a marriage have to make a declaration as provided in the 3rd schedule of the Act. No ceremonies are, however, required under the Act. Certificate of marriage. After the marriage ceremony is over, the marriage officer shall enter a certificate in the marriage certificate book under section 13 of the Act. The certificate of marriage issued is considered as the certificate of special marriage registration. Marriage certificate is a conclusive proof that the marriage rituals have been legally performed. Conclusive proof or evidence means final proof and nothing against it can be proved. But where fraud or deceit is exercised, the marriage would be challenged. Registration. Any marriage solemnized whether before or after the commencement of this Act may be registered under this Act if these conditions of section 15 are fulfilled. Ceremony of marriage has been performed and the parties are living as husband and wife. Neither party has more than one spouse living at the time of registration. Neither party is a lunatic or idiot at the time of registration. Parties have completed 21 years of age. Parties are not within prohibited degrees of relationship except where custom permits such a marriage. Parties have been residing in the area in which marriage is being registered for at least 30 days before applying for registration. On receiving an application for registration, the marriage officer shall, under section 16, give a public notice allowing a period of 30 days for anybody to raise any objection that they have against such registration. After the expiry of such period and hearing the objections when raised and inquired, if the marriage officer is satisfied that all the conditions of section 15 have been fulfilled, enter a certificate in the marriage certificate book, which shall be signed by both the parties to the marriage and by 3 witnesses. In the case of Deepak Krishna versus District Registrar, question for consideration in this case was whether section 15 clause F and section 16 of the Special Marriage Act 1954 are mandatory provisions or directory provisions, warranting a liberal interpretation taking into consideration of the hardship and inconvenience caused to the parties. The court took the view that clause F of section 15 is only a directory provision, and the failure to follow the said clause strictly would not make the registration of the marriage under the Act invalid. Failure to follow that clause does not render a thing only done in disobedience of it a nullity. It is true that a directory provision as such gives no discretionary power to do a thing not directed. Even if a provision is directory in nature, it should be substantially complied with, which depends upon the facts and circumstances of each case. Further, court held section 16 has stipulated a time frame for the public to respond so as to fulfill certain statutory requirements. Then the designation of time is a limitation or check on the public authority. Purpose of granting specified time of 30 days in section 15 is to ascertain whether the parties have complied with the conditions laid down in section 15 of the Act. If the conditions mentioned therein, especially from A to E of section 15, or not fulfilled the registration of marriage under the Act and the deemed solemnization of marriage under section 18 of the Act will have no legal effect as per section 24 subsection 2 of the Act. Consequence of non-compliance under sections 15-16. Rules 6 and 7 is provided in the Act itself. In our view, the time clause of 30 days prescribed under section 16 is a matter of substance, non-observation of which will result in the object of the provision being frustrated. Nature of the acts to be performed and the phraseology of the statute indicate an intention on the part of legislature to exact a literal compliance with the time stipulated. Contrary view would operate unfairly in prejudicing the rights of persons who propose to file objections on the basis of public notice within the statutorily stipulated time. We are therefore of the considered view that the time frame of 30 days prescribed under section 16 is a mandatory clause which is not liable to be waived. Effects of marriage on member of Hindu undivided family and succession. The marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh or Jain religion shall be deemed to effect his severance from such family. Section 19 lays down that any person whose marriage is solemnized under this act who was a member of an undivided family, his status shall be deemed to effect his severance from such family. This section has been inserted to keep peace and amity in the family. It is confined to Hindu, Buddhists, Sikhs and Jains. It is not mentioned whether he loses his right in the family or severance will affect him or her only. It appears that it will be a personal severance only, and that too it will be deemed to be so. As soon as marriage is solemnized under this act, the effect would be that he could no longer continue as a member of the joint family. Severance within the meaning of this section will have no reference to succession, as laid down in Ganga Dasi versus Bijay Singh 1950. Where a person solemnized marriage under Special Marriage Act, then he solemnized it according to Hindu Dharma Shastras. It was held in Raja Satyavrata versus Commissioner of Wealth Tax that he remained a co-partner and there was no severance from joint family. It would not make any difference to the status of family whether the marrying person belonged to a Mitakshara or Dayabaga school. A marriage, therefore, solemnized under the Special Marriage Act or in any other form and which has been registered under section 16 of the Act will ipso facto break the jointness of family so far marrying persons are concerned. This spirit is preserved in section 21 of the Act. Succession to property of the person whose marriage has been solemnized under this Act shall be governed by the provisions of Indian Succession Act 1925. Where a marriage is solemnized between two Hindus under this Act, section 19 and 21 will not apply. Section 21A. Their succession to property will be governed by the Hindu Succession Act 1956. Restitution of conjugal rights. According to section 22, when either of the parties to the marriage has without a reasonable cause withdrawn from the society of the other, the aggrieved party can file a petition for restitution of conjugal rights. However, such a petition will only be granted once the court is satisfied of the truth of the statements made in such a petition and when there is no legal ground why the application should not be granted. The court may decree restitution of conjugal rights. Section 22 of Chapter 5 of the Special Marriage Act 1954 lays down the conditions on which a petition for restitution of conjugal rights would lie. Restitution of conjugal rights: when either the husband or the wife has, without reasonable excuse, withdrawn from the society of the other, the aggrieved party may apply to petition to the district court for restitution of conjugal rights, and the court, on being satisfied of the truth of the statements made in such petition and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. Explanation: where a question arises whether there has been reasonable excuse for withdrawal from the society, the burden of proving reasonable excuse shall be on the person who has withdrawn from the society. These are the elements of the section. Number 1, the respondent has withdrawn from the society of the petitioner. Number 2, the respondent has withdrawn without reasonable cause. Third, the burden of proof of reasonable cause is on the respondent. Where by the act of other party, any of the spouse is compelled to leave the society of the other, then it is a reasonable cause for withdrawing from the society of each other. Desertion, neglect, cruelty, impotency, etc. are the incidents which may be considered as reasonable cause for withdrawing from the society of the other. In a case where on account of behavior of the husband, a wife was compelled to leave her matrimonial home, maybe with animus discerndi and animus non reverendi, then this physical departure would not be guilty of desertion. The burden to prove the fact of withdrawal from society with reasonable cause lies on the person who has withdrawn from the society. In a petition for restitution of conjugal rights, there may be a legal hindrance in granting the relief of restitution. For example, where it is found that the marriage is null and void, then no question arises to grant relief, because the remedy is open to valid marriage and not to void marriage. Similarly, adultery is another ground on which the restitution can be refused. Petitioner must come to the court with clean hands. Behavior of the husband or wife is also a ground to refuse restitution. Drinking, physical violence, apprehension of causing grave danger to life, utter cruelty, leading flirt life, etc. are also grounds to restitution refusal. Maintenance. This section 36 of Special Marriage Act contains provisions with respect to maintenance pendent light for those who are married under this act. The section reads as alimony pendent light, where in any proceeding under Chapter 5 or Chapter 6 it appears to the district court that the wife has no independent income sufficient for her support and the necessary expenses of the proceeding, it may, on the application of the wife, order the husband to pay to her the expenses of the proceeding, and weekly or monthly during the proceeding such sum as having regard to the husband's income. It may seem to the court to be reasonable, provided that the application for the payment of the expenses of the proceeding and such weekly or monthly sum during the proceeding under Chapter 5 or Chapter 6 shall, as far as possible, be disposed of within 60 days from the date of service of notice on the husband. Maintenance under this act is available to wife only. Under this act also, all that has to be taken into consideration while granting maintenance is the fact that the wife does not have sufficient means to support herself or the suit. Order of payment of such maintenance shall be made to the husband once the wife makes an application to this effect. In Rajesh Burman versus Mitul Chatterjee, 2009, the court held that two expressions, maintenance and support, are comprehensive and of wide amplitude, and they would take within their sweep medical expenses as well. One must always remember that this act and its provisions apply to only those who are married under this act. Section 37 Special Marriage Act provides for permanent maintenance of the wife. The section reads, any court exercising jurisdiction under Chapter 5 or Chapter 6 may, at the time of passing any decree or at any time subsequent to the decree, on application made to it for the purpose, order that the husband shall secure to the wife for her maintenance and support if necessary, by a charge on the husband's property, such gross sum or monthly or periodical payment of money for a term not exceeding her life, as having regard to her own property, if any, her husband's property, and ability, the conduct of the parties, and other circumstances of the case. It may seem to the court to be just. If the district court is satisfied that there is a change in the circumstances of either party at any time after it has made an order under subsection 1, it may, at the instance of either party, vary, modify or rescind any such order in such manner as it may seem to the court to be just. If the district court is satisfied that the wife in whose favor an order has been made under this section has remarried or is not leading a chaste life, it may, at the instance of husband, vary, modify or rescind any such order, and in such manner as the court may deem just. Thus, Section 37 Special Marriage Act provide for the maintenance of the wife married under the Special Marriage Act. The Special Marriage Act 1954 is a special legislation and cuts across all the barriers of religion and caste. It allows two persons to marry under the provisions of the Act without changing their religious beliefs and faith. The Act provides for the procedure for marriage and the matters relating to maintenance, divorce, judicial separation, etc. With this, we come to the end of today's program. Hope you have understood it well. We shall meet again with new topic. Until then, take care of your good self. Goodbye.